warm good
Oh,
morning,
I'm
and
not able to
I
listen.
I also welcome you and lot of good wishes for the new year.
Able to listen the sound.
Yeah, welcome, ma'am, Miss Prakriti Malla.
Good morning, sir.
Good
How are you?
morning, ma'am. Fine. How are you?
I'm good, sir, and Happy New Year, sir. Belated.
Same to you, ma'am. Same to you.
Thank you, sir.
Yeah. So, how is life, Vikashji? How is life, brother? Am I audible to you? Yeah, yeah. Thank you. Thank you. You are writing your responses. Thanks. So, had you written something, some blog, some article, or few words? Okay, okay. I understand. I understand. Yes, Miss Prakriti,
Yes, sir. Yes.
have you decided to finally to opt for this paper?
For refugee process. Actually, sir, I haven't studied this subject earlier.
Okay. Yeah, please, Vikashji, please unmute mute yourself. Yeah, thank you. Yeah, Miss Prakriti, you were saying something. Yeah.
Yes, sir. Actually, I haven't studied this subject earlier in my BLLB days. And
Okay.
in this semester, we have to do a dissertation as well. So, like,
Okay.
there are three subjects in my list right now. International arbitration is must for me because of my dissertation topic.
Very
And
good.
apart from that, in dispute settlement and refugee law, I want to go with both the subject, sir,
Okay.
actually. But I'm still confused regarding whether I will be able to manage the time for dissertation as well or not. Because if I go with both of these subject, there might be some time problem, time issue. But I will try to go with both of these subject as far as I can, sir. That's why I'll be joining both of these class.
Yeah, most welcome. Most welcome. You will get all kinds of cooperation from my side. This is
Thank
what
you,
I
sir.
can ensure. Yeah.
I know this, sir, very well. You are the most cooperative person,
Yeah.
sir.
Yeah. Thank you.
And
Thank
even
you,
the
ma'am.
first semester student were also telling the same to us that
Okay, okay. So you guys are interacting online,
yes,
I
sir,
think.
with some
Very,
students. Yeah.
yeah, very good, very good.
Sir, did you uh, went for some holidays?
No, brother, no. I do
Stella
not have
ma'am,
such kind of pleasantries or luxuries in life.
Stella
Yeah.
ma'am had gone Maldives, ma'am,
No, 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 brother, no.
and she shared me a photo.
Because for me, if you take into account, because why we go, because of some better weather conditions. So Delhi is a place where you will get all kinds of weathers. So rather, it does not mean that I am casting some kind of a negative impression upon others. That is not my intention, but it has never been my preference. Since my birth, I have never been in the habit of enjoying or visiting some or going abroad for holidaying. So that has never been my cup of tea. What is important though, and that is the bone of contention in the family, that my family always prefers that, and they are not very happy with my scheme of things. So they always impress upon me that I must accompany them and take them somewhere for a change of weather, but I'm not able to do all these things.
Good morning, sir.
Yeah, good morning, brother. How are you, Jamshed Bhai?
Sir, I am good and I was very keen to see you. I'm very happy to see you again.
Yeah,
And
I was equally viewing for your beautiful interactions, your faces, everything.
sir,
Good
So
morning,
what's
sir.
I,
I
Good
hope
morning,
you are
sir.
doing
good
good.
morning, Imran Saab. Yes. How are you?
Sir, Alhamdulillah, sir, everything is fine there in
Yeah.
Bangladesh,
So
sir.
you are there in Dhaka.
Yes, sir, yes, sir.
Yes. Yeah. And Mr. Rakib? You are also there in Bangladesh?
Good morning, sir. Yes, sir. I am in
Okay.
Bangladesh.
What about
So,
you, Asif bhai?
Good morning, sir.
Good morning. Where
How
are
are you
you
doing,
right
sir?
now? Where are you right now?
I am in Delhi, sir.
Okay, okay. In Akbar Bhavan.
Yes, sir. Yes, sir.
Okay, good.
How are you doing, sir? How is your
Yeah,
health?
I'm fine, brother. I'm fine. I'm doing well. So I will also share with all of you my latest contribution that is likely to be published in this month itself. So, and that is exclusively, devoted to international refugee law. So I will share that contribution with all of you. That is very, very important because I have written something about artificial intelligence, a full-fledged research paper in the context of international refugee law. So I will share that very paper. So I got the first print which I have corrected. They wanted my approval, so I have approved with minor modifications in the draft and sent that back. So that would be very much, I think, you would be keen to conduct a post-mortem on this particular contribution. And fortunately, it is going to be very thematic, very relevant in our ensuing engagement in the area of international refugee law.
Sir, is it published from India or elsewhere, sir?
Pardon?
Sir, I'm saying that whether it is published from India or outside.
No, it's a Brill publication,
Okay, sir.
an international journal. It is outside. It is published in Europe.
Yes, sir. It is very famous, Brill.
Yeah. So I will definitely share. So it's a very lengthy research paper because it took almost. I started this research paper in the beginning of in the month of March in 2019. So it consumed a lot of time, lot of research. So it is a 70-page paper. So it's a huge one. So I will definitely share with all of you. So only 7 students are there, 6 or 7 students are there. So if you allow me, should I begin or should I wait? Wait for others, because it's very, very important, because I would like to make a presentation of the global picture of the refugee crisis with the facts and figures. And thereafter, we would switch over to some other important aspects. So please tell me.
Sir, I'm little bit curious about
Yes.
relation of how artificial intelligence is affecting the refugee all over the world, or creation of refugee crisis all over the world. I'm little bit curious.
About artificial intelligence.
Yes, sir.
Okay. So let that paper be out. It would be a little bit premature to deliberate, because I want to discuss that particular research paper, and I'm equally interested to have your feedback and your comments on that very paper, so that, because right now I again started another important dimension, and that too again in the area of international refugee law, vis-a-vis artificial intelligence. The paper which is being published by Brill Publications, that is having a different dimension, and now I have taken up a different dimension. So your observations, comments, your inputs, your interventions, and your responses would also be equally important for me, and I would definitely be incorporating those inputs with a citation with your inputs. If I'm there would also be an acknowledgement in the footnotes. Due credit would also be given to all of you if I am going to have, though the exact language I would not be incorporating, rather it would be my language, but the credit would be given to the specific names who are making some plausible pragmatic contribution. So it's very important. Definitely I will share that very publication with all of you, and thereafter I would invite your comments and observations. At the same time, you would be given at least 10 days to come out your feedback, so that I should reflect upon, and I should incorporate those reflections, comments and observations in the ongoing project of mine. So as of now, I have already completed around 20 pages. And it will take another 10 pages. It is going to be a very small one, the 30 page or 28 pages research paper, again on the another important aspect of refugee protection and how that aspect has been subjected to artificial intelligence and the role of the artificial intelligence in the asylum cases. So we would be deliberating on these aspects. Well, before I proceed, and I should at this stage simply request you that in the very first, though tomorrow I would also give you a full-fledged orientation as well as the overview of the course structure, and the course structure is also under updation, improvement and review. As I have mentioned and submitted in my email yesterday in the night, that latest version of the course structure would be there on the FLS-SAU website latest by 15th of January. And I am updating it while incorporating the latest developments. But you should also remember, if it has been updated, or it is likely to be uploaded on the university website, it does not mean that it is not going to be updated or improved further. On daily basis, all the course structures are improved, and right now I have been improving comparative constitutional law of SAARC nations course structure. Though that is not reflected, these improvements and inputs, it is not possible to incorporate in the existing course structure that is there on the university website. I am equally, engaged in updating international human rights law course structure. That is under review right now. On daily basis, I am incorporating some of the, important developments in the area of international human rights law. Then I am again very much, engaged in improving another important, course structure that is also an optional one. That is international media law that would be offered in the second semester. Though it has not been operationalized as of now, but from this year itself, it is going to be implemented. So I am also improving that particular, course structure, and the refugee law, that is international refugee law syllabus, that is also under updation. So we have been, means I am including all of you. You are going to be the equal partners in the improvements exercises. So what is important for me, allow me to request you at this stage, if you feel that any of the dimensions which you feel that should also be reflected in the course structure, you should also email me about that particular aspect. That is my submission to all of you in a form of a request. Another one is, you should also cajole what exactly you are going to prefer, I mean, preference for topics for your refugee law term papers. And remember one thing, since refugee law is the most burning issues in the current scenario at international level, so all your term papers should be of very high quality so that you should be able, after completing them, after submitting them to the department, to me, you should be able to, with minor modifications, with lot of consultations among yourselves, and even from or inviting inputs from me, you should be able to get them published as a full-fledged research paper. This is my, again, a very, very important advice to all of you. Another important dimension is that as many as more than 6 or 7 students have been doing their LLM dissertations in the area of international refugee law. So for them, it becomes very, very important to attend with punctuality all the online classes of international refugee law. So these are some of the important items which should be there as one of the most important part of your entire academic and intellectual itinerary. Now I take you to another important dimensions, and that is relating to the week first. Tomorrow I will provide you the entire overview of the course structure and what I have, new areas which I have incorporated, and presently I have been deliberating for their incorporation in the existing course structure of international refugee law. But before I proceed further, I would like to impress upon you, as you are already well acquainted as a student of law, that there are certain important requirements. Requirements in the sense that each and every subject has got certain highly specialized terminologies, assorted meanings, specialized expressions, which should also be the part of our understanding. And these understandings are going to be pervaded, going to be reflected in entire engagement in the area of international refugee law. And therefore, this is my humble submission that all these terminologies must also be the part of your understanding. Suppose if we are studying psychology, science, or some kind of genomics, avionics, so these are the areas where highly specialized terminologies are generally resorted by the people and without any kind of explanation. Suppose there are some important dictionary meanings, and these dictionary meanings, you understand, the literal meaning has also been given. Suppose there, for example, the word asylum, the word assimilation, the word persecution. If you take one single word out of these, 3 important examples, which I am sharing with all of you, and that is asylum. So in medical terminologies, this particular term conveys a different kind of an understanding and meaning. We understand that there are, asylums or mental asylums where the people who got some kind of a mental retardation, they are generally housed, they are kept for a special kind of treatment, medical treatment, psychological treatment, and physical treatment. But when we use the word asylum in the context of international refugee law, it becomes or conveys a very different meaning. Asylum means the grant by a state in the context of international refugee law. Grant of what? Of protection on its territory to persons who are fleeing persecution, who are fleeing some kind of a conflict, who are fleeing war, serious or irreparable harm, or for other reasons which have been defined in the national law as well as international law. Basically, the idea of asylum encompasses a variety of elements, including protection against non-refoulement. Again, it's a new kind of a terminology, non-refoulement. Though as a student of international human rights law, you might have studied the Torture Convention. And in Torture Convention, whatever the limited deliberations that took place in the previous semester, but I recall that I have mentioned Article 3 of the Torture Convention of 1984, where the word expulsion has been used, but it is synonymous to the idea of non-refoulement. Though it is written as non-refoulement, but since it is a French terminology, so we in English also pronounce as per the French pronunciation requirements. So it is pronounced as non-refoulement. It means there should not be any kind of a forced expulsion of somebody. It is one of the most important human rights state obligation that has been incorporated in various international human rights law framework or treaty frameworks. Over the years, this particular idea of non-refoulement has also attained the status of customary international law, because there is no dearth of scholars who have rightly pointed out that this particular idea of non-refoulement has attained a status of just cause, a status of customary international law. It has become a preemptory norms of international law. And Professor Guy S. Goodwill, who is the undisputed authority, and he has become a professor emeritus in the area of international refugee law. And right now, he is there in the Oxford University, is one of the most important colleges, and that is All Souls College. He has also came out and supported this argument that the non-refoulement over the years has attained the status of customary international law. There should not be any kind of a forced expulsion of aliens, non-nationals, non-citizens, immigrants, refugees, stateless, asylum seekers who happen to be on the territory of the country of reception or the country of destination. So this has been the understanding about non-refoulement. At the same time, let me remind you at this stage, though we would be discussing, because the full-fledged deliberation has also been devoted to the idea of non-refoulement in one of the subsequent weeks. The idea of non-refoulement, so far the refugee instruments are concerned, the concept of non-refoulement has also been incorporated under Article 33, subclause 1 of 1951 UN Convention relating to the status of refugees. And that is going to be the main instrument, main subject matter which we are going to deliberate as a subject matter of international refugee law. And there is another important instrument that is considered, and that is we are rather going to consider, and that is Additional Protocol of 1967 to 1951 UN Convention relating to the status of refugees. So these are going to be the major two important instruments. Though there are other instruments as well, like recently concluded two important global compacts of 2018, the Global Compact on Refugees and the Global Compact on International Migration. So these two components are going to be the latest additions in understanding and addressing the problems of refugees and refugee crisis. Another important, instruments would also be, there are many instruments, but I am simply, talking of the specific instruments, particularly in the area of statelessness. The 1954 UN Convention on Statelessness and 1961 UN Convention on the Reduction of Statelessness. These are going to be another two important international conventions which we are going to deliberate. Now I am taking you back to the terminology part. Tomorrow I would be making a broad, what we call, presentation on the overview. So that is the meaning of asylum. So time and again, we are going to resort to this kind of an expressions during our engagement on international refugee law. Another important example which I have, narrated before you, that was relating to the word asylum. And there is another important, word, that is assimilation. We understand what exactly is the meaning, the literal meaning of the word asylum. Assimilation. But in the context of international refugee protection, how should we use this particular, word? Assimilation conveys adaptation of one ethnic or social group, usually a minority. Generally, it is used in the context of a minority or some special, what we call, ethnic group. Assimilation, my dear friends, involves the subsuming of language, traditions, values, morals, and behavior, or even fundamental vital interests of identities. That is the meaning of, assimilation in the core, because the issues relating to refugee protection, it has been the fundamental understanding of all the geopolitical entities that refugees should not maintain their distinct identity if they have been, received in a country A from their country of origin, that is country B. So in the country A, that is going to be the new home, they should also allow themselves to be assimilated in the new territory. They should abandon their culture, identity, their special vital interests with regard to identity and culture. And they must allow themselves to be assimilated in the new, what we call, traditions. That is the understanding. However, the traditional cultural practices of the group are unlikely to be completely, abandoned. On the whole, assimilation will lead one group to be socially indistinguishable from other members of the society. But assimilation is the most extreme form of culturalization, I should say. So this is how assimilation is generally resorted by the new nation state whenever they receive and they feel that there should be a policy of reintegration of the new population of refugees in their, countries. And this is what we have, witnessed in the European refugee crisis. And I would also be deliberating as a separate topic. So far, the European refugee crisis is concerned, and whatever the agreements have been signed between EU and Turkey, and how the Bangladesh has been hosting the Rohingya refugees, and what kind of an issues the government of Bangladesh has, confronted with, and the latest drive of the government of Bangladesh to shift a sizable number of refugee population of Rohingya refugees into a particular island, and how this barren island is likely to be rehabilitated and habitated by refugees or with refugees. So we would be deliberating these, issues in the subsequent, weeks. Because the separate, when we are going, because separate week has been, demarcated for the contemporary international major challenges and issues confronted with refugees or are being confronted by the refugees. Then there is another important, term, as I have just now used, and that is known as the country of origin. How this expression is going to be used. Country of origin means the country where an asylum seeker, refugee, or migrant comes from, and which he or she possesses the nationality. In the case of a stateless person, my dear friends, the country where he or she has his or her habitual residence. Suppose, let me exemplify it like this. There are stateless people in Bangladesh. Because of their siding with the army of the Western Pakistan in the War of Liberation of 1971. So there are, a considerable population of people who hailed from state of Bihar, state of West Bengal of India, and they sided with the army of the Western Pakistan when there was East Pakistan as well, which is today's Bangladesh. So during those days, they sided, and thereafter, when Bangladesh has emerged on the world political map as an independent nation state, that the newly established government did not recognize these, people who sided with the Western Pakistan's army as their own citizens. They have become stateless, and the subsequent agreements were also concluded between the newly established state of Bangladesh with its erstwhile, nation state, I mean the Western Pakistan, and the Western Pakistan or today's Pakistan has promised they would also be taking them back and they would be rehabilitated in the province of Sindh in Pakistan. Similar has been the cases in other parts of the world. So these kinds of people are known as the stateless, though I would also be discussing what is the definition of a stateless person as per Article 1 and Article 2 of 1954 UN Convention on Statelessness. Then there is another important terminology which we are going to resort in our engagement in this particular program on international refugee law, that is the word detention. You understand, as a student of constitutional law of Bangladesh, constitutional law of Afghanistan, and constitutional law of Sri Lanka, you understand what exactly is the meaning of the word detention. But we are also going to understand the word detention in the context of refugee protection. Primarily, what we are going to study, if we try to casual rummage the contours of this particular term, that is detention, deprivation of freedom of movement, usually through enforced confinement. That is the basic understanding. If you take into account Article 31, under Article 31 of 1951 UN Convention relating to the status of refugees with its additional protocol of 1967, then under this convention, it has been provided that certain safeguards in relation to restrictions of freedom of movement for refugees who enter or reside in the country illegally, they are generally detained or put under detention. United Nations High Commissioner for Refugees, that is the nodal agency empowered to look after and monitor the refugee movement globally, which is in abbreviation is known as the UNHCR. So UNHCR Executive Committee conclusions are also there. And under one such conclusion number 44, under this particular conclusion, certain important standards applicable in the situations of detention have also been contemplated and envisioned. So this is how we have to understand the idea of detention. because it is having some kind of a ground, and that is a legal ground, a legitimate ground of detention. Though so far the political parlance is concerned, it is altogether having a different kind of a understanding. There are many countries even where the political prisoners, aliens, non-nationals, non-citizens are generally kept. And the detention camps controversy was also there in India in the recent what you call months. But there are nation states who are not from what we call the detention centers. Like the most notorious detention facility is known as the Guantanamo Bay. But there are detention centers and detention facilities in Libya, in Jordan, in Egypt, in other Middle Eastern, Western Asian countries. No, there are, I mean, majority of the nation states are there, and they are harboring all these kinds of detention centers. Even right now in South Asia, particularly in Pakistan as well as in India, we are also having detention centers. There are as many as right now in India 5 or 6 detention centers happens to be in operation. I have to check the facts on this particular point, but I am having this information. There is another important term which is generally resorted to by the scholars of international refugee law, and that is expulsion. I have already mentioned Article 3 of the Torture Convention, where we find a mention of expulsion. But in the context of international refugee law, expulsion is an act by a state authority with the intention and effect of securing the removal of a non-national from its territory. That is the understanding. And this is what we have been witnessing whenever refugees are deported, expelled, and repatriated. Refugees lawfully on the territory of the state can only be expelled for reasons of national security and public order. These are the two important grounds which are always resorted by the host nation states. National security, terrorism, and threat to territorial integrity. These are the grounds which are generally invoked, and these grounds have also been given, my dear friends, in one of the most important provisions of the 1951 UN Convention relating to the status of refugees, and that is Article 33, subclause 2 of this particular convention, where the national security arguments have got some kind of a leverage. But if you take into account and contextualize the recent adoption of the New York Declaration of 2016 during the Obama administration in the United States of America on migrants and refugees, and under this in New York Declaration, two important instruments were adopted in 2018. That is I'm talking of global compacts. Then these global compacts have also neutralized this particular second clause of Article 33 of Refugee Convention, that is the 1951 UN Convention relating to the status of refugees. So here lies one of the most important frameworks that has been contemplated on global compact on refugees. And that is popularly known as the response, refugee response framework, comprehensive refugee response framework. So under this particular, framework, a fourfold protection mechanism has been contemplated by the Committee of Nations. At the very initial stage of the refugee problem has been considered by the nation states as a domestic issue. Thereafter, it has attained the status of, continental dimensions. And continental dimensions also came out with the continental solutions. Then this problem got divided into two broad categorizations, that is global north issue and the global south nation states issue. But at the very start, the refugee problem has never been recognized and regarded as an international issue. It has always been addressed as an internal problem, as a transnational problem, in other words. But at the same time, in all these developments, whatever the developments over the years have happened, if I start from the Westphalian model of refugee protection or the refugee crisis. So since the Treaty of Westphalia of 1648, this problem has never been politically addressed. And it was the biggest achievement in the second decade of the 21st century. The politicality of this particular refugee crisis or the refugee problem has been realized by the collective wisdom of the nation states. And that too under the leadership of President Obama in 2016, when the New York Declaration was adopted. New York Declaration is the only document in the entire refugee peregrination since the inception of humanity on this beautiful planet. And when we are talking of refugee crisis, then for the first time it has been realized that refugee crisis is not only the humanitarian crisis, but it is also a political crisis. Earlier it used to be addressed as a political crisis. Now it has become political crisis. So it requires the political palliation for its resolution. And it has been decided by the collective wisdom of the nation states, and they deviated from the Geneva-based wisdom to the New York-based wisdom. And it was the New York Declaration, because the 1951 convention was adopted at Geneva. That is why I am calling it the Geneva-based wisdom. So if you see the journey from Geneva-based wisdom to New York-based wisdom, you will realize, my dear friends, that there is a lot of developments that have taken place. And one of the development is the political realization of the community of nation states. And for the first time, refugees have never been what you call felt in the New York Declaration as burden of international community. Rather, burden sharing term has been shifted to another important exalted terminology that is known as the responsibility sharing. It was the New York Declaration under the Global Compact in 2018, Global Compact on Refugees, that international solidarity has been recognized as one of the key features of addressing refugee crisis or refugee problem. So if you take into account, though I would be very much keen to have a detailed deliberations on these nuances, what exactly has been there. But at the same time, since we are deliberating right now and it is a very limited brief, and that is confined to the usages of certain specialized terms and terminologies and expressions during our engagement in international refugee law. So this is how we have to understand. But I am at the same time giving you some nuances and some vital dimensions of this entire what we call crisis, that is the refugee crisis, and what has been the pattern and practices of the various nation states. So this is how we are going to address. Another important term that we would be using, and that is forced displacement or forced migration. It means the forced displacement or forced transfer of population or the forced migration. It means the coercive departure of people, or under duress, if somebody is compelled to move from his habitual residence, that is known as the forced displacement from his home country or country of origin. And when we are talking of forced displacement, then there is a risk of persecution. There is a possibility of other form of serious or irreparable harm that is likely to be suffered that very person who is fleeing from persecution or fleeing from conflict or war. Such kind of risks can exist due to the armed conflict, serious disturbances, massive violations of human rights, disturbances of the public order, natural disasters, climate-induced situations, or the inability or unwillingness of a state to protect the human rights of its own citizens. So these are the various situations. These are the potential situations which may warrant the displacement of people. So this is how we should try to understand the idea of forced displacement. Then there is another important dimension, and that is known as the internally displaced persons, IDPs, what we call. We are also having certain important international instruments in the form of a soft law with regard to addressing internally displaced persons. Suppose persons or groups of persons who have been obliged to flee or to leave their homes or places of habitual residence, particularly as a result of or in order to avoid the effects of the armed conflict, situations of generalized violence, violations of the human rights, or natural or anthropological disasters, and who did not get an opportunity to cross international borders. They move from one place to another place within their own country. They are generally known as internally displaced persons. And we are having some important what we call instruments on them. Though there is a full-fledged regional arrangement for them that has been contemplated under the Kampala Convention of 2009. Kampala is a name of a city in Africa where this particular instrument has been adopted by the collective wisdom of the African Union in 2009. But before 2009, there has also been a soft law, and that is equally applicable even in today's circumstances. That is 1998 UN guidelines on internal displacement. That is a soft law. And these guidelines have also attained a the greater amount of importance in the area of international refugee law framework. So this is how we have to address. These are known as the guiding principles, but we have to take into account the de facto refugees, displaced person, externally displaced persons, uprooted people, or climate refugees as well. They should also be taken into consideration when we are, because I would also be one particular week has been devoted to the climate refugees, and we are going to deliberate their rights as well. Then people generally ask one such question which is related to the economic migration or economic migrant as such. So who is an economic migrant? So this should also be understood, because economic migrant is someone who leaves his or her country of origin purely for financial or economic reasons. Economic migrants choose to move in order to earn a better life, and they do not flee because of any kind of a persecution. There is no coercion in their fleeing. But somebody may ask because of poverty or some other important considerations, because of the economic boycott, because of economic recession, people may move, and these factors should also be taken into consideration as a coercive methodology for their migration. So that is altogether a different what we call dimension, or rather these are the secondary reasons. But the first reason is that generally the economic migrants are those people who, just to eke out a highly dignified and financially viable what we call existence in the society, they generally go for the greener pastures, and that is why they migrate. But they do not fall within the criteria of refugee status and not entitled to receive international protection. That is a note of caution. Then there is another important term which we are going to use, that is EXCOM. It means EXCOM means Executive Committee of the UNHCR. This is the short form of that executive committee, which I would be using as EXCOM. So that should also be taken into consideration. There are some other important terminologies like irregular what we call movement or immigrants, like refoulement, non-refoulement, and non-refoulement, whatever may be the pronunciation that I have already explained to you. Then resettlement, that is another important terminology. Then we are also having some other important words like persecution. Persecution is different from what we call prosecution, because the word persecution has not been what we call defined, and that is the beauty of the Refugee Convention. The word persecution has not been defined, but its forms have been defined under under Article 1 subclause A, where the definition has been provided of the term refugees. One particular week has exclusively been devoted to the idea of what we call definition, and what are the shortcomings of definition, what exactly are the other important imperatives which requires our attention, that should also be taken into consideration. So this is how we are going to understand the idea of what we call of refugee protection. At the same time, I am going to make a presentation of lot of paradoxes, political paradoxes and political contradictions. We are going to use another important terminology, that is the Second World War or the post-Second World War scenario. These kinds of expressions would also be there. But the expression World War Second or World War First is highly problematic for me. As a student of international law, I do not concur with this kind of an expression. You might be wondering why am I speaking like this, and that too in a regular class of LLM. And what has been the reasons why I did not come out with this kind of a engagement in the area of international human rights law or in the area of comparative constitutional law of SAARC nations. Because of my hesitation, intellectual hesitation, that I should not dismantle well-established expressions. It is an optional paper, and that gives me a lot of liberty to air my views. Because if you see the history of wars, the repercussions and ramifications of wars could be international, but the wars are not international. This is my legitimate understanding. You have every right to disagree with me. You can dismantle my notions of understanding. Because when we are talking of World War First and World War Second, I see them as continental wars. I see them as European wars or Europe wars. I see them as global North wars, but I do not see them as world war, because that becomes very, very problematic for me. Because when somebody or some nation states are going for war, or they are siding with one particular country or nation state as an ally or as a combatant or as a participant in the hostilities, they should be branded as the full-fledged participants. For example, take the example of the World War II. No country outside Europe has participated in this particular war. The people of colonies of the British Empire or some other empires and their colonies, they were subjugated and compelled and coerced to participate. They followed the imperial orders, but willingly they haven't participated, and the political consensus was not there in those colonies. So primarily, whether it was the World War First that was wrongly captioned as World War First, or the Second World War, again that is wrongly written like World War Second, though it was the Europe War First and Europe War Second. Even the decolonized scholars would also be holding the same view. Though I haven't studied any of the scholars with these kinds of expressions, this is exclusively my understanding. You have every right to disagree with me. Because in the right now I am working and writing a paper, and that too again in the context of refugees. I would also be sharing some of the important dimensions of that very paper tomorrow. And for the first time, you will come to know how the idea of what you call of refugees and the persons of refugees, treatment of refugees, protection of refugees, how it has been what you call ventilated, and how I'm going to navigate it. Because the refugee crisis or the current global refugee crisis requires a new country of what you call among the community of nations, which should also be a country of refugees, if you take into account the entire refugee population. Because the 1% of the entire world population constitute a population of refugees. That is the understanding right now, if you take into account what exactly are the numbers of refugees. Though the refugees, if you take into account, we are having, globally speaking, 26 million refugees are there. I am talking of refugees alone, my dear friends. But if you take into account the refugees under the direct mandate of the UNHCR, Palestinian refugees, for which another important international agency has been created under the auspices of the United Nations organizations, and particularly under a subsidiary organizations of the United Nations organizations that is known as the United Nations High Commissioner for Refugees, UNHCR. Then there is another, category of people, internally displaced persons. Then there is another important category of asylum seekers. And for the first time, we have been witnessing the creation of a new category, my dear friends, and that is Venezuelan refugees and Mexican refugees. A new class of, refugees, and new additions in the refugee population. So cumulatively speaking, if you take into account all these, fragments of populations and put them in under one umbrella of forced displacement, then today we have been, witnessing that there are 79.5 million displaced people in the world, or refugees, literally speaking, not legally speaking. Otherwise, we are having the intersectionalities of this population. So that is the, situation right now. So 79.5 million forced what you call, population, and that is up to what you call by the end of 2019, my dear friend. The new figures will also come out in the month of, June 2020. And in the month of what we call June 2021, we would be having new figures by the end of what we call the 2020. So that is the, situation. And how we are going to address this kind of a, morass, if you take into account this entire what we call, world population of refugees. And the most vulnerable and the most disappointing and distressing feature of this, global displacement of, population, if you further, study, you will find an estimated 30 to 44, or I'm sorry, 30 to, 34 million of 79 million forcibly displaced persons were children below the age of 18. That is the, most distressing aspect and dimension of this forced displacement at international level. And there are, new claims as well. New claims in the sense, asylum seekers have submitted, my dear friends, 2.0 million new entitlements and claims. United States of America was the world's largest recipient of the new individual applications of asylum seekers. And the United States of America, who has, received in 2019 as many as more than 3 lakh applications. And United States of America was subsequently followed by Peru, thereafter Germany, in Europe, and France and Spain. So you can very well understand what has been the, situation of asylum seekers. There are people in South Asia who have abandoned their nationalities. There are people in South Asia who have sought, nationalities of the different what we call nation states of South Asia. There are, individuals and group of individuals and individual persons who have abandoned their British, citizenship, and they sought citizenships somewhere else. So European nation states have also received applications from the asylum seekers, from the, citizens of other nation states, and they want European, citizenship. In the wake of the Brexit that has been operationalized from the 1st of January this year, that is the 2021, Many people of British origin who have always been Britishers, they have, opted for non-British, citizenship in other European nation states. Even the present Prime Minister of Great Britain, Mr. Boris Johnson, whose father has also contemplating abandoning his British citizenship because their roots are there in France. He is again moving from Great Britain to France, to his country of origin. So you can very well understand how the migration is taking place, and transmigration is taking place, retransmigration is taking place. Then we are also having, out of this population of 79.5 million forced displaced people, there are 5.6 million displaced people who have returned to their country of origin. So there is a population of returnees as well. But one of the most important aspect is, it is generally stood, my dear friends, that it is the global north nation states who have always been at the forefront of hosting refugee population. It's a kind of a misconception. It's a myth, because what we witness in newspapers, magazines, and so far the international media houses are concerned, they generally report that it is the European refugee crisis, it is the crisis of Europe, it is United States of America, it is Canada, Australia, New Zealand, and other European nation states or the global north nation states who are hosting refugees, and they are extending some kind of a humanitarian assistance and support to the new populations of refugees. This is untrue, my dear friends. This is not the reality. If you take into account the entire facts and figures, you will come to know 85% of the world refugee population is being hosted by the nation states who are hailing from the global south. That is the reality. But since they are not having big media houses, since the global north nation states are not having international media persons, since they are lacking the media pluralism, they are not able to what you call navigate or advertise their humanitarian actions. Otherwise, this is the reality, that they have been what you call hosting 85% of the world refugee population. I mean the developing countries. And out of this 85% of the hosting of the world refugee population, out of this 85%, 73% of refugees are being hosted in the neighboring countries. For example, in South Asia, Bangladesh. Another important example is in Africa and Europe. I mean, I'm talking of Turkey. More than 3 million refugees are being presently hosted by the government of Turkey from other parts of the Africa, I mean Middle East and the northern part of the Africa continent. People from Syria, people from refugees from Syria, refugees from other neighboring nation states, Turkey is hosting. And that is why Turkey has entered into an agreement with the European Union. We would be dealing with subsequently so far what has been the nuances of this particular EU-Turkey treaty, what were the political compulsions, whether it was the political ploy on the part of the government of Turkey, or was it simply a humanitarian crisis. So we would be sifting all these nuances at a subsequent stage. So 73% of the world population, refugee world population, got shelter and cloth in their neighborhood. So you can very well understand how these people are being hosted and what kind of a treatment they are getting. As of now, up to, if you take into account, though I am not what you call discussing 1 decade of the refugee protection, that is going to be though I would also be deliberating the how 1 decade particularly that it starts from 2010 and comes up to what we call 2019, this entire decade, what has been the response of the governments, institutions, legal institutional responses, individual responses, NGOs and civil society institutions responses. So we would be dealing with that particular aspect as well, and what exactly has been the major crisis, particularly in terms of the legal reception as well as the statutory reception. Then almost more than 1 million refugees have also been resettled. This is another important achievement of the international community, that this much of population has been resettled in various parts of the world. But the most important worrying point is, if you analyze the entire refugee population at international level, then the 68% of the entire refugee population comes from 5 nation states. And these 5 nation states have really hosted, I should say, these 5 nation states have hosted the entire world community. You can take the Syrian Arab Republic, number 1. It has produced 6.6 million refugees. It's a refugee producing country. Then the second important country we are having, that is Venezuela. It's the latest addition. It has produced, my dear friends, more than 3 million refugees. 3.7 or 8 million refugees it has produced. Then we are having again Afghanistan in South Asia. It has produced as many as, my dear friends, 2.7 million refugees who have been sheltered in the neighborhood. India is hosting Afghan refugees, Iran is hosting Afghan refugees, Pakistan is hosting Afghan refugees, Bangladesh is also hosting Afghan refugees. Very few Afghan refugees you will find. Central Asian republics in Central Asia, some of the republics have also been hosting Afghan refugees. That is the situation. In the neighborhood, they have been hosted. They got shelter. Then the fourth one is the South Sudan, a newly emerged, newly established nation state that comes out of Sudan, South Sudan. It has been what you call hosting as many as 2.2 million refugees. And the fifth one is Myanmar. It has also generated refugees, and the Rohingya refugees comes from this nation state. And they have what we call, uprooted 1.1 million refugees, Rohingya people. So these 5 nation states have hosted. They have, hijacked the entire, world agenda, and they compelled the entire world community to ponder over. 5 nation states, only 5 nation states in a community of more than, around 200 nation states. Out of 200 nation states, only 5 nation states have browbeating, and they have really, derailed the entire development agenda or the global development agenda. So see the role of these, nation states. 3.6 million refugees which have been presently hosted by one single country, and that is Turkey. Refugees have always been there. That is the current situation. If you take into account the interwar period population of refugees, how the people have been massacred in Europe. 1951 convention relating to the status of refugees is not a universal convention. It is not a global convention. It is not an international guarantee for the protection of refugees. Primarily, this particular convention was a European convention. It was exclusively enacted and adopted for the protection of intra-European refugees. And that is why when an instrument has been initially oriented and addressed a regional issue of refugees or regional problem of refugees, how can we say that it comes within the rim of what you call of international law, and now it has become international law instrument by adopting an additional protocol to it, which is popularly known as an additional protocol of 1967. And that is the reason it could not what you call receive a full-fledged endorsement of the community of nation states. As of now, only 146 or 45 nation states have ratified or acceded to this Convention of the United Nations Organizations of 1951, which is known as 1951 UN Convention relating to the status of refugees. So we have to take into account the factors which were responsible for this kind of a understanding of an instrument which was originally and initially confined to a particular region which is known as Europe. So it was basically a Europe war, not World War. That is first contention. As a student of international refugee law, I failed to understand why this particular war has been addressed as international war. Then we would also be, discussing, sir, some other important, nation states and how these, nation states have come out with certain important plausible understandings, figures, facts, and how that has, shaped the protection of the refugees and how the refugees have been, addressed. Another important dimension that I would like to bring forward regarding international human rights law, and that is relating to certain important plausible questions. And these questions must also be understood. There is a famous political theorist from France. Before I proceed further, and I try to what you call invoke the observations in her famous book, which is known as the Totalitarianism. I am talking of Hannah Arendt. How that lady came out with the idea of international protection of refugees. As per the course structure, which I am going to share in few days, 3 or 4 days, I would like to impress upon you, my dear friends, as a student of international refugee law, as a student of anthropology, as a student of political science, and as a student of comparative constitutional law or international law, You are advised to prepare and discuss the history of your family's migration within your own country or outside your country. So at least you should be able to write a 200 or from 200 to 500 pages and get it published. That is one important advice. It is a part of the course curriculum, though it is not mandatory, it is not at all compulsory. It's in form of a advice. Because a refugee biography is of vital importance. You should also try to understand the idea of refugees in media. Role of media, particularly whenever the media tries to report refugee plight and flight and refugee issues. So media reporting must also be assessed by the students. You should try to analyze and examine what exactly are the contours as well as the dimensions upon which the media has been reporting. It becomes particularly very important in nations who claims themselves to be wedded with diversity and multiculturalism, particularly like the South Asian nation states like Pakistan, India, Bangladesh and Sri Lanka, including Nepal. What exactly are the public attitudes towards refugees in these nation states from South Asia? That should also be examined, because in the subsequent what we call engagements, I am going to deliberate on these aspects. Because the public attitude, public opinion, public perceptions on migration, we have to recalibrate and we have to rethought. Because the entire philosophy of the public attitude and public perceptions must be reimagined, revisited. If you take into account how the idea of refugee protection under international refugee law has emerged, then we cannot forget that French theorist, a moment ago I have mentioned her name, and that is, she has been talking of right to asylum, despite the facts, long and sacred history of this particular right. But international rights of the nation state or international rights of a state, it has always been in conflict with the right to asylum. Why it has been in conflict, and why do states commit to protecting foreigners today? We have to what we call rummage this particular relationship, and we should try to understand how we are going to further analyze this particular right. So that has to be considered. Another important dimension that has also been pointed out by Hannah Arendt of France, and in the subsequent writings of the Harald Bont, a professor from Oxford University, and she has also established some of the important and vital institutions in Africa continent in its educational institutions. She has also been a refugee scholar and human rights authority, and at the same time an institution builder. So her contributions have also, to a very great deal, have also supplemented the subsequent, in a subsequent era, or in the post Hannah period. Because Hannah Arendt was of the view that the states constitutes the primary nexus when it comes to security for individuals and groups. And at the same time, we should not forget, my dear friends, the principal threats to human security are transnational in nature. And this is something which is opposite true for refugees and asylum seekers. With the transnational globalization expanding, my dear friends, our state is still the primary nexus of the security for the individual. That is the most important question, and it is going to be a litmus test for our understanding. Another important question that is also there, and that is relating to what difference does border crossing make to the international community's humanitarian obligations? If somebody does not cross any kind of an international border, then what are the state obligations or the community of nation states obligations in such kind of a situation? Because the international law is silent when there is a question of the internal migration or internal displacement. Why over the years international community could not come out with any kind of a protection mechanism for internally displaced persons? It is very difficult to attribute one single factor for the internal displacement. When development index and development models are calibrated and formulated in the towers of the international financial institutions or the Bretton Woods institutions, and they claim themselves to be the international financial entities, and the development models and modalities are formulated and conceived by them for developing nations and for developed nation states, or rather the developing nations are dictated by these agencies, and they are placed under the pressures that comes and mounted by the developed nation states. Then the developed nations are equally responsible for the human development, because human development as well as the human displacement, because the cost of the human displacement has to be borne by developed nation states. Take the example of the deforestation. Take the example of the construction of big dams, desertification, reckless development, lopsided projects implementation in such kind of, particularly in the developing nation states. And that is why right to development has attained a new kind of a dimension. And the right to development as a human right has got another important dimension, and that dimension gives us another important right, which is popularly known as the right not to be displaced, a right not to be poor, a right to belong, a right to historical roots. I have identified as many as more than 12 or 1 dozen rights of this kind of a nature. I would also be sharing those very rights. So that should also be taken into consideration, because these are some of the vital and very, very important questions. And these questions requires our profound attention. Another important dimension to it that is relating to the refugee status is a very privileged category vis-a-vis other important classes of coerced, displaced, or coerced, what you call, or compelled migrants, I should say. So in such a situation, what other classes are there? Is there any kind of a possibility to create multiple classes of human displacement? And do they require international protection, particularly, as I have mentioned, internally displaced persons? Or should internally displaced persons should be, categorized on the basis of the factors? Suppose there has been climate change. Climatically displaced persons, CDPs, should we address and categorize this? Or natural disasters, or some other important or industrial development induced internal displacement, should it constitute a new kind of a category? So these are the, some of the important, questions which should also be taken into considerations. But before that, there is another important, category. Not only the category, but there is a vital overarching, question, and that is why study international refugee law and forced migration. So that is another important, dimension. Why do people move? What is the reasons of their, movement? What caused their mobility from one place to another place, within the country, from one place to another place, or by crossing international, borders, and why and where did people go? So these are the some of the other important questions, and definitely I would be coming out with a lot of plausible answers and responses to all such kind of questions, after making first an overview, a presentation of overview, what exactly we are going to do in international refugee law tomorrow. So thank you very much for the day. I have, I think, agitated your minds and given you a brief, what you call, outline of the entire, what you call, global scenario of the refugee crisis, some figures of the displaced, what you call, populations, their intersectionalities and categorizations, but the ultimate result has been forced displacement. Then some, terms and terminologies and their importance. I would also be, sharing a dictionary of refugee law, and that should be the accident feature of a companion of your study. And some requisite primary text would also be shared. So today I am intent, or by tomorrow I would be sharing a lot of stuff on this particular engagement. So thank you very much, my dear friends. The rest of the things I would be attending tomorrow very positively. So thank you very much. If you have any questions, so you can ask. Yeah, ask.
Thank you, sir.
You're welcome. You're welcome.
Hello.
Hello.
Sir?
Yes, Mr. Satya.
Yeah, I have one question, sir.
Yeah, please.
Like, we have a 1990 Migrant Worker Convention adopted as a human right instrument. So, does this treaty have any relevance in the context of this refugee law?
Yeah, I have already, taken it. It has been incorporated in one of the weeks, ma'am. We would also be coming, because the rights of, migrant workers, we have to deliberate. We have, I have, taken another important, dimensions. I mean, some of the international law, international human rights law frameworks would also be getting a full-fledged treatment in this particular, paper. So basically today I have confined exclusively to the refugee issues, but I haven't dealt with the other important ancillary and fringe and vicarious issues. So those, vicarious issues, fringe issues, and incidental and connected issues will also be getting our attention. So definitely that is there, ma'am. It is a part of the course structure.
Thank you, sir.
You're welcome. So thank you very much, my dear friends. See you tomorrow.
Thank you, sir.
Yeah, thanks a lot. Thanks a lot, brother. So I have been actually today that most of the students are not there. Only 10 students have joined today. So I am waiting for others, because I don't want to indulge in any kind of a platitude. So let there be, I mean, if there are people and they are willing to join, opt for this particular paper. So that is why I have been brief in my submissions. So the detailed submissions I will begin from tomorrow. Thanks a lot. Thank you very much.